I will now call case 1277745, State of Kansas versus Jeremy Francis Volle.
May it please the court, Peter Meharry for Jeremy Volle. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted. Thank you.
Thank you. This case comes before the court after my client was convicted of the most severe charge of felony murder. It involved a shooting here in Topeka. Essentially came down to two co-defendants pointing the finger at each other. And one co-defendant, Brandon Krosky, eventually reaching a deal with the state to plead to murder 2 and a sentence of around 10 years, and for his trial testimony pointing the finger at Mr. Volle. We've raised several issues with regard to that conviction. The first issue we raised on our brief, and what I'd like to start with today, is the issue with regard to the search warrant that was issued to search my client's phone. There was a search warrant. The Topeka Police Department did a cell phone extraction where essentially it took everything off the phone, and then it was searched by the detectives on the case. There was a motion to suppress below, arguing that the search warrant itself was overbroad. That was denied eventually. The district court eventually found there was no probable cause for the search warrant, but that it was saved by the good faith doctrine and allowed the evidence from that search to be admitted at trial. It's our belief that the district court erred in that finding. We believe that it erred in finding that the search warrant was not overbroad. If you look at the search warrant, and it's part of the record, it basically allows for the search, and this is also what the detective testified to, it allowed for the search of everything and anything on that phone. And we believe that violates the Fourth Amendment and the particularity requirement that is contained within that constitutional amendment. So with that being so overbroad, allowing the police department and detectives to search everything and everything, we believe the good faith exception also doesn't apply, because an officer in that position would recognize that it is.
Counsel, I'm sorry, can I back you up to just a procedural question about the probable cause finding? Sort of, I don't know, I found it to be an interesting procedural question that the state briefs that issue as sort of an exception to preservation, that the district court was right for the wrong reason, but doesn't cross appeal on that issue. Is that enough to get this issue before the court, the probable cause finding?
I believe they had to cross appeal that finding by the district court. The district court clearly made a finding of no probable cause underlying the search warrant. The state has that opportunity to appeal that in a cross appeal. They chose not to, and I believe that is necessary. Otherwise, they're basically stuck with that ruling. And as far as right for the wrong reason, I don't think that saves the day. When you're talking about right for the wrong reason, I think you're looking at cases where the district court decides on A, this court says no B, but not in a situation where the district court makes a finding and the state has the opportunity to say, no, that finding is wrong, and I'm going to take an appeal from it. They did not do that here, so that probable cause finding stands. As I said, the district court found no probable cause for the warrant, which we agree with, but it did find that it was still saved by the good faith exception. And we believe the overbreadth of the warrant, the fact that it allows the officers to search everything on the phone, no limitations. In this day and age, we keep everything on our phone. Our entire lives are on our phone.
Wasn't there evidence that this was a routine request and had frequently been granted by many judges? Does that counter your argument about?
I don't think it counters my.
Officer should have some belief.
There certainly was testimony that the officer, detective testified that this is standard language that they use, and he has not had issues in the past. But he also testified, yeah, it allows me to search everything on the phone. Just because you've been able to do it in the past doesn't counteract the fact that it is so overbroad and allows the search of everything on that phone. A reasonable officer should know that the Fourth Amendment has that particularity requirement. You just don't get general warrants. And that's what this is. This is a general warrant for his phone. They searched everything on that phone.
What shouldn't they have been able to search?
They should have had to say in their search warrant, either by dates, by apps, what have you, to limit them to search certain things, like for text messages on certain dates, like for phone calls.
Is
on
that-
certain dates?
Is there tension at least with, I mean, you said there's no such thing as a general search warrant. Is that really true? I mean,
Well, I would say that there are general search warrants. I would say they're constitutional.
well, a search warrant to search a home, for example.
Right. But usually you have a specific thing you're looking for.
Right. You
And
have a description with particularity of what you're searching for,
Right.
but isn't that different from a limitation? In other words, a search warrant for a home, oh, you can only look in the dresser and under the bed.
Well-
They don't work like that, do they?
I would say that it depends on what you're looking for. If you're looking for a stolen car and you get a search warrant for a house, I don't think you get to search the entire house for that car. You
But if
have
you're-
to have limitations on the warrant.
If the particular limitation on a cell phone warrant is evidence of a murder, why can't you look in the whole phone?
Because they have no basis to believe that there's anything on there other than what he testified to, maybe some calls, maybe some text. There's nothing else. He testified as far as like, he talked about, maybe there's GPS location tracking data. But he testified, yeah, I had no idea if that was on. I had no idea if there would be anything. We still require probable cause. We still have to have a basis to say, we're going to search this because of this information we have, and we believe there's additional information there to be found. They didn't have that here. All they had was a general warrant to search that phone, and they searched everything and everything.
The warrant does include basically every app on the phone. I mean, lists all of that, but it also includes follows that with the words and any other form of electronically stored information associated with either crime listed herein, or identifying information to determine ownership. How is that much different from what we do with house warrants, where we say, search the house for evidence related to this incident?
I would say with this, that limitation isn't in fact no limitation at all. It is so broad and so over expansive. It is in fact no limitation. When you talk about like a search of a home, you do talk about search for specific pieces of items, pieces of evidence that you think will be there. And here it's just generic statements about apps, messages, multimedia messages, etc., or any other form of electronically stored information. That's just everything. And the Fourth Amendment requires limitations. It is there to protect from these general warrants, and that's what this is. So we believe it was overbroad. It is not, and as a result, officers should have known. And it is not saved by the good faith exception as the district court erroneously found. I would like to touch on the third issue as well, and that deals with the instruction on aiding and abetting. The district gave that instruction at trial over the objection of the defendant. In this case, as I said, it was essentially two co-defendants, each pointing their finger at the other. The state's main witness, Brandon Kosky, testified, I didn't know he had a gun. I didn't know he was going to pull it out and shoot. Jeremy testified similarly. I didn't know Brandon had a gun. I didn't know he was going to shoot this guy. There's no indication that they were working together to do this shooting. There has to be some evidence that they were working together. This is a joint venture. They both were intending to do this, and that is absent here. We have evidence that they were acting alone. Each of them testified to that, and that is not enough for the aiding and abetting instruction. And in here, we believe it is problematic because it does give an alternative, additional theory of criminal liability for the state to pursue. And certainly when you look at what transpired after the jury was instructed, the jury did ask about aiding and abetting, asked for clarification on aiding and abetting. And we would argue that that certainly gives the indication that they were at least considering that as a form of criminal liability for my client. And without a proper factual basis, they should not have been doing that. So we believe that was also in error and cannot be considered harmless given the jury's deliberations. Final thing I would touch on is I would like to touch on issue 5, which deals with the sufficiency argument dealing with the felony murder charge. We have argued that there was insufficient evidence for the underlying felony criminal discharge at a vehicle. And in this case, the uncontroverted evidence was that shot was fired at a person. Now, the person was by a car, but if you look at the evidence, and the state pointed this out in closing arguments, the gun used in this case had a laser sight on it, and you can follow the laser sight. And the testimony was, you could see it on the road, you could see it on the car, no shots fired. When the wife testified of the victim, when she saw it on her husband, she heard a pop and he was struck by a bullet. That is firing at a person.
That's the actus reus, right? The discharge at, right? So we're not talking about intent. So,
Yeah, I don't care why the shot was fired.
right.
What I'm looking at is what was done, the act underlying the charge.
Well, isn't that just a word that's sort of a function word that indicates an occurrence happened in, at, or near? I mean,
I would disagree with that because that's not what the language of the statute says. Language of the statute is specific at a vehicle. The language of the statute.
that's what I mean. The definition of at is sort of directional. Why isn't that enough that it went in the direction of an occupied vehicle?
I would argue that when you look at the statute, it talks about criminal discharge of a firearm, talks about at a vehicle, talks about at a building. The legislature has clearly decided certain things, certain acts, what you're shooting at matter. If you're shooting at an occupied vehicle, it's a severe crime. And that is what was done, not done here. It was shot at a person. And just being close, what you're doing is you're opening up that statute. Any shooting in a parking lot is criminal discharge at a car then.
But if it's reckless conduct, it just seems like, how can it be that specific to?
Because that is what the language the legislature chose.
Distinguish that. You're testing my memory here, but a long time ago, long time ago for me, we dealt with State v. Farmer,
Correct.
which pretty much addressed your argument. How does it distinguish that here? That was, as I recall, a case where the defendant was very close proximity to the vehicle, almost up to the window. And there was kind of, maybe he was in, maybe he was out, but that was enough. And that your argument was the exact same argument made in that case. And we found the statute was satisfied in that general factual scenario. What's different here?
I think a couple differences, Your Honor. My remembrance of the facts is that they fired inside the gun, or at least very close, inside the vehicle, or
Right.
very close. My understanding was that there were multiple shots fired, and not only the victim was struck, but also the vehicle. That's different facts than what we have here. We don't have anything close to that. And I would,
Well, wasn't he like inside the door? I can't,
I think that's correct, Your Honor. My recollection of the facts was that he leaned in the car and shot. And the argument was, well, that's not shooting at a car, that's shooting at a person. But there were multiple shots fired in that case.
yeah,
And
but here, what do we have? We have
we have one shot.
one shot.
One shot that was only fired when the laser sight was seen on the victim. When it was seen on the road, when it was seen on the car, no shots fired. The act here was clearly shooting at a person who was standing
Inside a vehicle, correct?
He was standing outside the car, Your Honor.
Okay.
He had gotten out of the car, he had waved his BB gun.
And that's what I was asking. The door was open. I'm just trying to get the.
Yeah, my understanding is that if this is the car, the door was here and he was here. And he was shot from roughly a block away. So I think it's different factually. I would also acknowledge Levy is out there. But that one also, you had multiple shots fired. That was essentially a running little gun battle between rival gang members. But you had multiple shots, and the victim in that case was shot in his vehicle. Bullet struck his vehicle. And in both those cases, I think the court made the mistake of looking at intent instead of the act.
So on that point and on Levy, there's language in Levy that says that the crime of criminal discharge, and it talks about does not require specific intent to shoot at the motor vehicle. But then the court goes on to say, as opposed to some other target, whether that target is inside the vehicle, hiding behind the vehicle, or only nearby the vehicle. Does that cut? I mean, it seems to cut against your argument.
And I fully acknowledge both Levy and Farmer cut against my argument. And I've said in my brief, and I'll say it here, I believe this court took the wrong path by not sticking to the language of the statute.
Would you say that at a minimum, at least for you to prevail, we would have to, again, at a minimum, at least disapprove that language in Levy?
I would think you would have to, because I think that language, again, going back to the statute and what it covers, that language broadens it. If you have a person in a parking lot standing by a car, person comes up and shoots at him point blank, is that shooting at a car? I would argue it is not. And I would argue that is not what the statute is supposed to cover. The statute is supposed to cover drive-bys, right? That's why it was here. Shooting up cars, shooting up houses. And the legislature said, we're looking at when shots are fired at vehicles, at buildings, etc. And here we don't have that. There's insufficient evidence for the underlying charge. As a result, we believe there's insufficient evidence for the felony murder as well. For those reasons, we would ask the court to reverse, as we've argued in our brief. Thank you.
Ms. Smith?
May it please the court, Assistant Deputy District Attorney Carolyn Smith for the state of Kansas. Your Honors, I would like to start on the issue that was just ended on regarding the statute for criminal discharge of a firearm at an occupied vehicle. In this case, I believe there is a factual argument that the victim was in the vehicle in some sense. The driver's side door was open. He had stepped away from it to point his BB gun as the defendants were driving by. He returned to the vehicle. He put his BB gun back inside the car and was standing there being told to get into the car when he was shot. There is an argument that being inside that open door area includes being inside the vehicle. And as defense counsel stated, this statute is to prevent drive-bys. And that is what we have in this case. We have two cars driving down the street and one of them starts shooting at the other. Now, whether he hit the person, whether he would have missed is all based on seconds of time. And whether the sight was accurate or not, we don't really know. It may have been. We know that the victim said, or the victim's wife said she saw the laser sight on his body before she heard the pop and he fell to the ground. But was that the shot? Was that the area of his body that was hit with the shot? We don't know. I would say that this court should uphold its ruling in Levy and the verbiage that says it doesn't matter if the person was in the car, hiding behind the car, near the car. The fact is there was a car there with a person in it when the gun was fired. And being in that area sufficiently supports criminal discharge of a firearm in this case.
The wife was actually in the car, right?
That is correct, Your Honor.
So it was occupied by the wife, regardless of where the guy was standing, right?
That is correct, Your Honor. She was in the car and she could have been hit in this case, whether the angles were proper for the fired shot to have gotten in and through the door and hit her, whether it hit the actual victim in this case. All of these things are possible because of the distance and how accurate or inaccurate that laser pointer scope is uncertain. But we do know that there was a gun that was fired at an occupied vehicle in this case, sufficiently supporting the underlying felony for the felony murder count.
How do you respond to counsel's argument that anytime you fire a gun in a parking lot, you're guilty of this?
I think it depends on how the shot is being fired. If you're in a parking lot and you're firing the gun straight up into the air, you're not firing at a vehicle. You could recklessly kill somebody that way, depending on where the bullet lands, but you didn't fire at a vehicle. However, if you're in a parking lot and you're firing at the cars in that parking lot and somebody's inside, you have committed the crime of criminal discharge of a firearm at an occupied vehicle.
If I'm standing in a parking lot and I shoot, if I'm standing in Target's parking lot and I shoot at the Target building, am I guilty of this crime?
I believe the statute covers at a vehicle or at a building, and you've now shot at a building. Then you've, in that case, it would be criminal discharge of a firearm at an occupied building.
Right, right.
I guess that would result in a more factual analysis, very different from the case we have here, because whether or not, shooting at the outside of a thick
Shooting at an open
building,
shooting at an open field over vehicles is covered by this statutory crime.
I believe so, Your Honor. Yes.
But I mean, if they're occupied,
Yes, Your Honor. Of course, the vehicle must be occupied. If it's just a field of vacant cars, then this would not be the case.
So you think it's that expansive? You have an open field. There's a vehicle that's kind of parked there and there happens to be someone sitting in it. And you shoot in the direction clearly over the vehicle, you're guilty of this crime.
I think if you're shooting in an open area and you maybe don't hit the vehicle that happens to occupy a person, there's an argument to be made that the crime was not committed because the vehicle nor anybody was injured. There's an argument to be made there.
Isn't there a very good reason for the legislature to make it a crime to recklessly discharge at an occupied vehicle? It doesn't matter. Why does it matter whether it's in an open field or in a Target parking lot? I mean, the whole purpose of this is that when you do this behavior, people can get killed or severely injured. That seems to me to be the whole purpose.
That is correct, Your Honor. And I think getting into the purpose of the statute and why it was written as a general intent crime is because sometimes in some cases we're not able to ascertain what the actual intent of the shooter was. Now, just because in this case there was a laser scope, he was attempting to aim at a person, doesn't change the fact that if we start to limit it in this case, it then becomes limited in all cases, such as the hypotheticals raised here today, that you might not know if there's a person in the car. It might be in a large open area. It could result in any sort of harm, death, or injury to any sort of person when you're shooting a firearm near, at, or around a vehicle. And that's why the purpose of the statute still applies here today, despite the fact that in this particular case, maybe intent could be ascertained, but it still doesn't change the fact that there was a person inside a vehicle in the area where the firearm was shot.
Let me test the defendant's claims in maybe a slightly different way. I understand sort of the nut of the argument to be actually that there's insufficient evidence of recklessness here. That the operator of the firearm was so proficient, was a Robin Hood, would never miss his intended target. Is that a thing with this statute? In other words, could someone say, well, yeah, the bullet went near a car, but I'm such a proficient marksman and I had such a specific intent that there was no possibility I was going to hit that car? That
does not change the applicability of the statute, Your Honor, because that is going directly into the intent of,
Well, do you have to rely on the nesting doll statute that basically says when intent is proved, so are all the lesser states of mind? Because there is a difference between recklessness and intent, right?
yes, Your Honor.
For example, to another hypothetical, a hunter, a very accomplished hunter, who hits his target, shoots in the open field, and there happen to be, young teenagers parked in the field or whatever. That's not reckless conduct, is it? That he doesn't even know that they're there.
That is true. That would not typically fall under reckless, but
But is he still, would the statute still apply?
but this, yes, Your Honor, the statute would still apply because for any level of intent higher than reckless automatically proves the
Right,
lower
that's
intent.
sort of what I called the nesting doll.
Yes,
If you had intent, you also had reckless state of mind.
yes, Your Honor.
Does that make sense in the context of this statute? It may not matter whether it makes sense or not.
I don't know that it has to make sense because this statute is a general intent crime. You don't have to fire the weapon with intent or with reckless intent or with specific intent because it's for criminal discharge of a firearm. It is a general intent crime. So the state didn't have to prove that he was specifically meaning to shoot at the car. You have to believe the recklessness has to be separated from the criminal discharge of a firearm to support the reckless second-degree murder count in this case, which was the lesser included to premeditation that the jury convicted him of. And it's okay for the jury to make a determination of guilt for different crimes based on different types of intent. So there was no intent requirement for the underlying felony for the felony murder count in this case. So whether or not it was reckless only goes to support, or whether he had the specific intent only goes to support the other count of murder that he was ultimately convicted of. But that fell secondary to the first-degree felony murder conviction ultimately.
I'd like you to address getting to the motion to suppress. So number one, would you agree that you failed to preserve the, I guess, objection to lack of probable cause?
Yes, Your Honor, I would agree. The state did not cross appeal that issue. And I would also agree that there's precedent by this court that is almost identical that this argument would fail. However, I would argue that appeals are made and taken to counter adverse rulings, and this was not an adverse ruling for the state.
Where is it required that it has to be an adverse ruling?
I don't believe for cross appeals, I don't believe the requirements are as stringent for cross appeals. I don't believe it has to be an adverse ruling. But as the state ultimately succeeded on the motion to suppress, going back and cross appealing the one, I guess, lost issue or every minute lost determination by the court maybe counters the ultimate ruling, which was that the motion to suppress was denied.
Okay, so if we would find against you on that, can you talk about the good faith exception?
Yes, Your Honor. So stating that, moving on to that probable cause did not exist in this warrant. the good faith exception applies because the language in the warrant was not overbroad. It specifically listed, the officers wanted to search in the phone, specifically the call logs, the text messages, multimedia messages, pictures, videos, information from third-party apps, contact lists, device locations, and other information related to the crimes listed within the search warrant. Now, the detective from the police department testified that when they do these kinds of warrants, they've attempted to tailor this language to comply with the requirements of the Fourth Amendment. And in fact, because the technology simply doesn't exist to pick and choose this data out of the cell phone, they give it to a third party, a detective within the department, but one that is not a party to this investigation, to download that data and then generate a report so that such information can actually be chosen specifically to comply with the warrant. In this case, the detective testified that after he got the report, he started by limiting his search to the dates and times of the text messages that would have occurred between the co-defendants in this case around the date of the murder and the days following, to look at their communication, what they were talking about, pictures that were sent, and then he continued his investigation from there. It was impossible within the warrant to state, I'm looking for specific types of apps or specific types of text messages, because like searching in a house, you just don't know where or what specifically you're going to find. But by stating all of the specific,
So what I understand you saying is that even if you have a warrant that is overbroad, okay, that you can search everything, and you're applying a good faith exception, that if the officer actually, when executing the warrant, limits it, then does the good faith exception apply? I mean,
Your Honor, I do see that my time is run. If I can continue to answer the questions that the
Yeah.
court may have.
Yes, you may.
Thank you. So it's not just the language of the warrant. It is whether the officer can, based on that language, sufficiently determine and find what they are meant to be looking for. And in this case, the detective used and relied on this language to limit his search and conduct it in a way that still complied with the Fourth Amendment requirements. So this wasn't just a generalized rummaging of the defendant's cell phone. He didn't go back to years prior to this murder to find a text message between him and his sister. He was looking specifically for the communications between the co-defendants in this case, and anything else that was related to specifically to the weapon that was used. I believe the 10th Circuit case, US v. Otero, is frequently referenced. I know it was referenced by the defense below and discussed by the district court below, that the language that was used in that case was generalized. The warrant included both physical locations and technological locations, but the language did not limit the search of the technology in that case by any means. It was just the officers are allowed to search this. And that was deemed overbroad, but that is not what was in this case, where the language was limited to the crimes, and the crimes are limited to a certain time frame. Based on that, until additional technology is created, until data can be extracted from computers or cell phones in a more isolated manner, officers have to try to comply with the requirements of the Fourth Amendment in as best a manner they can, and have used this language in an attempt to do that. And the whole point of search warrants is to comply with the constitutional rights. For these and all the other reasons, the state has argued in its brief, we would ask that the convictions and the sentence be affirmed in this case. There are no other questions. Thank you.
Thank you.
May it please the court. Couple points. I'll start with what opposing counsel left off with. With regard to the warrant. The testimony was that the extraction, you had to take everything. I don't know why that would be the case, but that was the testimony. Seems like you should be able to pick and choose in today's day and age, but that was the testimony. The Fourth Amendment protects us from overbroad warrants. If the officer gets an overbroad warrant and says, well, I'm just going to limit my search, that does not save the warrant. We look at the warrant and what that authorizes. We do not rely on the discretion of the officers who are actively investigating the crime to limit their search in compliance with the warrant, or excuse me, with the Constitution. We require a specific and particular warrant authorizing the officer to search certain things, certain places. The other thing, he didn't limit his search. He didn't limit it to time. The pictures in this case of the gun, of my client with the gun, were outside the time frame he started with. So he started with the time frame, then he just kept going. The testimony.
The time frame of what? Say that again, I'm sorry.
Detectives testified that he started with a time frame from around the time of the crime until the arrest. But the pictures were beyond that time frame. So maybe he started with a limited search, but then he went beyond it.
Doesn't that cut directly against your argument?
No, that's
They found evidence at least relevant, maybe not very material. I mean, maybe distantly so, but it's evident, at least showing that he owned the gun on the phone.
the fact that they found evidence doesn't mean they had probable cause to search.
I understand
And that's
that.
what we look at.
Well, I
And you
understand
can't
that.
say, I'm sorry, go ahead.
But I'm limiting my question to your overbreadth argument.
Sure.
I understand there's a probable cause issue also.
Sure.
But if your argument is we need these very narrow warrants that are strictly limiting, and then you say, see what happens when they look elsewhere, they find more evidence. It just seems to cut against your claim.
I would disagree. I believe that we need particular and specific warrants based upon probable cause. And you can't say, well, we need to just hands off and let them search so they can find the evidence. That's not how the Fourth Amendment works. It's there to protect us from these general searches. This is searching everything and anything on that phone. And it amounts to the detective getting a warrant saying, well, he's being charged with the crime of first-degree murder. I need to search his phone. And the court signing off on that and allowing him to search everything on that phone. So we believe that the warrant was overbroad, and the detective certainly didn't limit his search. He searched that phone and he found evidence, sure. But that's not proper when you have an overbroad warrant.
Okay, so if you, if a magistrate signs a warrant, in a similar situation like this, before cell phones existed, wherever, and the warrant said, you know, search his home, for evidence of, you know, this or whatever, and they're going through, instead of text messages, they're letters back and forth, paper letters. So they're searching through a file cabinet for letters, and then there's photos of his gun. You would say about, you know, I mean.
Well, I would say it would depend. When you're looking at text on a phone, that's separate from looking at photos on a phone. If you're saying, well, you're searching a house and you see these letters, and within these letters are photos, that's a different thing. You're searching where you're supposed to be searching for these letters, and you're finding other things.
But couldn't there be photos related to the crime? I mean, that's what the warrant said.
There could be.
I mean, I think it specifically said that. So, I mean.
Well, the warrant said everything, frankly. I mean, the language in the warrant said any and everything. So I don't think you can say, well, it
related
said
to the crime.
that's
So it's
only
just the same
restricted.
thing as, you know, if you're looking for an elephant, you're not going to look in a file cabinet.
Correct.
Right. Okay. So, you know, I'm trying to think, so it's just, all right, I'm done, sorry.
The other thing I would want to touch on, going back to the sufficiency argument, and we were talking about hypotheticals. And it seems to me what the state is arguing is that if you have a hunter who's hunting in an open field and there's a car somewhere in the open field and he fires a shot, that's criminal discharge of firearm at an occupied vehicle. And I think the language in Levy and Farmer is too broad and it covers way too much. And if you look at the statute, there are several things the legislature has outlawed. Discharge at a building, discharge at a vehicle. But there's also misdemeanor charges where you're talking about firing on land, on water.
Do you agree with my characterization of your argument? I'm sorry to have done that, but give you a chance to disagree with me. That what you're arguing essentially is my client was not reckless because he had intent and he had the skill and the weaponry to exercise that intent. There was nothing reckless about this.
Your Honor, that is not what I'm trying to argue.
Okay.
So if that
appreciate
has
it.
come across, that is my mistake. My
Well,
argument.
when you talked about the laser being, on the guy and his intent was
Sure.
to shoot the guy, and that struck me as an argument against recklessness. I mean, in other words, he wasn't being reckless at all.
And
He knew exactly what he was doing. and he
maybe
did.
that is an argument that could have been made. That's not the one I'm making. My argument is you looking at the act, and what the act shows is that the shot was fired at a person. It was not fired at that car. It was clearly fired at a person, and that is not sufficient to support the underlying felony in this case.
And your exchange raises a question that may or may not be relevant, but now it's in my head. So wasn't there evidence that the defendant here made a statement that he was questioning whether or not the laser worked? And one of the things he was trying to figure out if the laser did focus and work correctly, or
There was
that line?
There was some testimony to that effect. That was contested testimony, but there was, I believe it came in through the co-defendant, Brandon Kroski,
Co-defendant,
who
okay.
struck a deal with the state, that my client made that state, something along those lines. I was seeing if it worked. But again, that was certainly contested evidence, and we don't believe that ever took place. But be that as it may, there was some evidence to that.
Okay. Any other questions?
Thank you, Your Honors.
All right, thank you. Thank you to both counsel for your arguments today. The court will take this matter under advisement.